Good afternoon, and welcome back to the 2021 Annual First Amendment Conference at the UVU Center for Constitutional Studies. I'm Scott Paul. I serve here in the center as Interim Director and Executive Director. I hope you were able to enjoy the first two sessions this morning. If you missed either of them, check back next week at uvu.edu/ccs/events or on this YouTube channel for recordings of the sessions of this conference. As we come to the final session of the day, I need to thank Carrie Dennis, our events and marketing manager. Carrie and her team have seen to all the publicity and logistics for this conference. They're the ones producing the online sessions. So we thank them. Also, speaking on behalf of my colleagues, I express gratitude to UVU Provost, Dr. Wayne Vaught, and UVU President, Dr. Astrid Jimenez, for their support of the center. I also thank the members of our advisory board for their invaluable guidance. Several of them actually were especially helpful in developing this conference. Now, it is my pleasure to introduce you to our moderator for the session. Dr. Nicholas Cole is a senior research fellow at Pembroke College at the University of Oxford. Now, this morning, I introduced Dr. Cole as a 21st century superhero because he is both a marvelous American historian and a brilliant computer coder. He invented the Quill Project, an award-winning, groundbreaking software platform that creates interactive visual and textual models of the constitutional conventions and the congressional debates that produce our nation's governing documents. Dr. Cole, thank you for joining us today.
Thank you, Scott. It's an enormous pleasure and honor to be here and to be chairing this session looking at the culture war issues and consensus building at the court. It's my duty to introduce Ryan Owens, who will speak for about 25 minutes, half an hour, and then take questions. And as a bit of housekeeping, you can either ask questions as the talk's going on in the YouTube chat, or you can email constitution@uvu.edu. A little bit about Professor Owens. He's at the University Wisconsin-Madison, where he's a professor of political science and an affiliate faculty in the law school. He's also an honorary fellow in the Institute for Legal Studies. He studies law and courts and American political institutions. He analyzes in particular the United States Supreme Court, the United States Courts of Appeals, legal institutions, and judicial behavior. And he's been published widely in many journals. He's also taught before his current post at Washington University in St. Louis and at Harvard. Professor Owens.
Great. Well, thank you very much. Appreciate that. And thanks to Scott and folks at UVU for this. I met Scott a few years ago, and I think he's just doing a fantastic, marvelous job over there. So I appreciate the opportunity to be a part of this today. So I am going to talk a little bit about consensus building and the Supreme Court today. It's a tricky issue to examine some of these culture war issues at the court. I think folks have said in the past that when the Supreme Court has gotten itself in the most trouble, it's when it has tried to get out in front of an issue that we might consider to be a cultural war issue, that it's tried to get out there in front of it and tamp it down. So whether we're talking about abortion, or if we go back in the day and look into the reaction that the court had in the Dred Scott case, there are a handful of cases out here where the court has sort of stepped in front of public opinion on a hot button issue. It's gotten itself in trouble. So that's always lurking in the background a little here as we talk about consensus building in the bench today. So I would like to start us off here just with a brief slide. Hopefully everyone can see this on where the justices are today ideologically. Now, what I have listed here on the x-axis, the bottom one, the horizontal, is the court term. And then on the y-axis are the ideology estimates of the U.S. Supreme Court justices from 1937 until roughly today. As you look at this axis, smaller values here represent more liberal values, and the larger the value on that y-axis, the more conservative the justice is. And I think the figure does a decent job of explaining how, or showing how, throughout most of the court's history, right, we can see that most of the justices are right in this region here, which is more or less a fairly moderate area. There have been, of course, a few justices over time who are considerably more or less conservative than others. So right here, this line that I'm following, you can track here, that's William Douglas. One of the most liberal justices ever to serve on the U.S. Supreme Court, at least in modern times. And then over here, we've got Thurgood Marshall and William Brennan. Whereas up on the top here with this bright yellow, this is William Rehnquist when he got on the court as an associate justice. And you can see that for his first 10, 15 years or so on the court, he's very, very conservative. And then after he becomes Chief Justice, he moderates, which is a trend that we see among associates who become chief. And then up here, of course, we've got Justices Scalia and then Thomas, with Thomas anchoring the court over time. So this gives you an idea of kind of where the court has been historically and where it is today in relation to that. And here are the current justices who are sitting on the court. This doesn't include Justice Barrett yet, simply because we don't have enough data to figure out where to place her on this ideological spectrum. But you can see that we've got Clarence Thomas kind of anchoring the right, and then Justice Alito, and then we've got this cluster of Gorsuch, Kavanaugh, and Roberts kind of anchoring the center right of the court. And then Kagan and Breyer, with Sotomayor. Once she got on the court, she was fairly liberal and has drifted to the left even further since she's been on the court. So you get Thomas anchoring the one end, you get Sotomayor anchoring the other. Alito kind of pushed out towards the right a bit, and then these folks right in here clustered. Now the question is, on some of these hot button issues, where are these justices? So these data are providing us sort of average ideological estimates on some issues. You can imagine some justices are more conservative than others, and more conservative than the average might indicate. And so it places the court in an interesting situation to figure out how, on some of these most contentious of issues, how the justices can get unanimity, or if not that, at least some consensus. So I want to start off first and just talk about why the justices might want to enhance their consensus and their civility. And this, of course, focuses on the court's need to maintain its legitimacy. So I think, as most listeners and viewers will know, that the United States Supreme Court doesn't have a direct electoral connection. And so absent that connection, it's bereft of the standard kinds of claims to legitimacy we're used to hearing in a democratic republic in terms of the consent of the governed. And so it makes it difficult for the court to stake out a claim or lay claim to legitimacy. It has to focus on the rule of law. And that becomes difficult to do with hot button issues where it's going to divide 50% of the electorate right off the bat. And so for the court, enhancing its perceived legitimacy is incredibly important. That's its sole power of persuasion, is that root base of perceived legitimacy. And it has worked tirelessly over the years to enhance that perceived legitimacy, to the point where today it has quite a lot of it. There are few courts in the world that could have decided the outcome of a presidential election, such as the contested 2000 election, that could have decided it in the way that this court did and actually survive. And I think the court's survival in that is a testament to the perceived legitimacy that it has among the public. But that legitimacy, I think, is certainly coming under stress today, with courts' decisions right out of the gates, polarizing half of the population or near half. That's troublesome to the court. And we know statistically, looking at responses to court's decisions, that they can influence people's perceptions of the court as an institution. So those specific outputs can actually impact the broader general diffuse support that the court has. The confirmation process for the U.S. Supreme Court is getting more and more contentious every day, to the point where Chief Justice Roberts has actually gone out in front of the cameras and said, look, it's really hard for people to understand that we're apolitical when they see the nomination and confirmation process as politicized as it is. But believe us, we're doing everything we can to remain apolitical. There's a reason why the chief went out and said that, is because that confirmation process is making it harder for the court to maintain its legitimacy. And we've seen, again, through the data, that when the court does things like overrule existing precedent, that it can have an effect on its perceived legitimacy if people believe that the court's not playing by the rules it's supposed to be playing by. So all of this stuff we know has an effect on the court's legitimacy, which in turn, as I said, is incredibly important for the court's long-term sustainability. But the question, I think, for today is, what happens when people see more and more sniping on the court, when they see justices taking pot shots at one another, fractured opinions, things like that? What role does that have on the court's legitimacy? I think there is cause for concern on that topic. So I want to focus a little bit on what the chief can do to play a role in this process. So how can the chief tamp down some of the negativity that we see? What can the chief do to enhance consensus on the United States Supreme Court? Now, this is by no means an exhaustive list. I've got 3 things that we can talk about, but there surely are other things that we could talk about in the Q&A if people have questions about them. But I think this is worth a discussion. So I think chiefs can do 3 things to really build out consensus, particularly in the environment in which we find ourselves today. And that's modeling good behavior, pursuing good leadership skills, and then focusing a bit on structural surroundings. Some of these are going to be obvious, some of them less so. So let's talk first about modeling good behavior. In a previous study, I examined the text of the court's opinions to determine what kind of words justices are using in their opinions. And there are a lot of different software packages a person could look to. You can roll your own, or you can use off-the-shelf type stuff. This is a very simple dictionary of affect and language, I believe it was. And that looks at the percent of very pleasant words in various opinions. So what we've got here is a series of Chief Justices, starting with Chief Justice Earl Warren, and then we've got Fred Vinson, current Chief Justice John Roberts, then William Rehnquist, and Warren Burger. And you can see here the percent of very pleasant words in the majority opinions that they write, that the majority opinions in which they joined, and opinions where they were not in the majority. And what you can see is that some chiefs are a little bit more agreeable or use pleasant words more than others. And here on the right side of this figure, you can actually see comparisons between chiefs. So here we've got Rehnquist versus Vinson, and we can see that Rehnquist has he uses more pleasant words than Vinson does or did. And conversely, Warren versus Rehnquist, we can see some differences there as well. So some chiefs are using more pleasant or agreeable type words than other chiefs are. And this is not just a function of the facts of the case themselves, but this is the entire text of the opinions. And so you could imagine that a Chief Justice who wants to build consensus or finds it necessary to build consensus would use more pleasant words in an opinion. And so we've seen some of that here. There are clearly distinctions between and among different chiefs. But this is perhaps the slightly more interesting analysis, I think. And this is the percent of nasty words that they use. And you can see among, let's take a look here. Where's Roberts? John Roberts is right here. So the percent of nasty words in his majority opinions is actually greater than his predecessors. Now, to some degree, it's statistically significant between some chiefs in the past and others, and not others. And you can see that here. So he's using him more than Vincent did, and a little bit less than Rehnquist. But you can see that Roberts himself is actually using nasty words in his opinions. When he's joining on to majority opinions that he didn't write, but someone else did, those opinions that he's joining use a lot of nasty words, at least relative to some of his predecessors. And you can see other opinions in which he finds himself separate opinions, either concurring or dissenting. Those tend to be slightly nastier as well. So, what is this telling us about John Roberts? It's not telling us a whole lot. It's not like he's hunkering down and trying to really get nasty with his colleagues. More than anything, it may suggest that the cases in which he's finding himself are split cases. But that alone, I think, is an interesting finding as well. It's just the cases where he's involved, one way or the other, are particularly nasty, or perhaps slightly more nasty than some of the other cases. And so this does indicate that, Roberts could potentially do more on the front end when he is either authoring opinions, or if he's a silent member of a majority, to say to his opinion writing colleagues, hey, let's tamp down some of the nasty language that we're using. Because that does have, one suspects, a consequence. The amount of aggression that you put out is likely to be reciprocated in kind. So that's just something for us to keep an eye on. It's just the text of the opinions and what they're saying, and the tone, really the tone that it's setting. So let's talk a little bit about leadership skills among Chief Justices. So probably 60 years, maybe 70 years ago now, Danelsky put out an article, a chapter that talked about Chief Justices and their leadership abilities. And he decided or defined that there were two kinds of leadership abilities among Chief Justices. There were some that were social leaders, and there were some that were task leaders. But the best were the Chief Justices who were both social and task leaders. So what did these concepts mean? Well, a social leader was just somebody who could keep the social cohesion together on the court. Someone that people looked to smooth over differences and make sure that everybody got on well with one another, or at least did so in a professional context. And then there were task leaders, and these were people who were kind of conscientious, who could keep the trains running on time. Not somebody that you'd go to if you had a concern on a personal level with a colleague, but somebody who would definitely keep the court operating smoothly from a task perspective. And so from Danelsky's point of view, the best leaders on the court throughout its history were those who were both social and task leaders. And for that, he looked at Chief Justice Hughes. Hughes was somebody who had a photographic memory. And so anytime anyone had a question about a precedent during conference, they could ask Hughes, and he would know just like that what the case was and what it stood for. And so that kind of skill led him to become a task leader. But he's also someone who really understood the politics of the matter. In fact, he ran for president at one point as the Republican nominee, and he was very, very well tuned to listening to people and understanding their perspective. So from his perspective, somebody like Hughes was about the perfect Chief Justice. And if you couldn't have that, the next best would be somebody like Chief Justice Taft, who was a social leader, not a task leader, wasn't somebody that people looked to understand every facet of the law, but who got on well with people and could help the court function smoothly. His task leader was Willis Van Deventer. So he would sort of farm out those questions to Van Deventer, the social things that would go through the chief. Everybody looked to him for leadership and cohesion. Well, unfortunately, Danelsky said there are a handful of people who have served as a Chief Justice who really didn't have either of those skills. One, of course, was Harlan Stone, who took a smoothly functioning court with well-run conferences and turned it really into a free-for-all circus. And we also had, from his perspective, Chief Justice Berger, who he argued was neither a task nor a social leader. And we saw some very, very significant fractures on the court. The problem that Berger faced was that he had an overwhelmingly liberal court for most of his tenure as Chief Justice, and he relied on a lot of his institutional prerogatives to try to corral justices and get the outcome that he wanted. So he would pass at conference when it was his time. Rather than voting, he would pass. And he did so because passing would allow him to see how all the other justices voted. The Chief Justice automatically has the most seniority on the court, no matter how long he or eventually she served. And so they always vote first at conference. Well, if you want to figure out where people are going to come down and then situate yourself in the majority so as to assign the majority opinion, you might want to wait and see how the conference discussion shakes out. And that's one of the things Berger used to do a lot, and it drove his colleagues mad. So you've got to have good leadership skills. It's unclear at this point where we find John Roberts. I think we all saw some press reports that came out over the summer that he has not been able to corral a lot of the justices. There's a lot of internal sniping on the court. So it's unclear precisely where Roberts is. I think by all accounts, he's a steadfastly highly respected man. But his ability to keep that coalition internally in check it's difficult, particularly when you have media sources constantly on the lookout for fractures on the court. Ultimately, what you want to avoid is something like this. This is a memo internally that went from Justice Douglas to Chief Justice Berger. Berger, as I mentioned, at times would kind of withhold his vote so that he could assign an opinion strategically to somebody that could either minimize the damage from his perspective or really give him what he wanted with an opinion. And that is what his colleagues were worried about in Roe v. Wade. This is a memo from Douglas to the chief. The court actually heard oral arguments 2 years in a row in Roe versus Wade. And after the first term of hearing it, the court opted to put it over on its calendar to the next year's term. And Justice Douglas almost went apoplectic about it, particularly after he thought that Berger assigned the opinion to black men strategically in a way that he ought not to have done. And you can see here that he is threatening to release to the media an opinion where he basically calls out Chief Justice Berger. Ultimately, that memo never saw the light of day in the public setting, but we have copies of it. We can see what he was about to tell the world about Chief Justice Berger, and it would have been very, very unflattering for the Chief Justice. So that's the kind of stuff you got to tamp down as chief. And leadership skills are going to be important in that context. We have yet to see, I think, really the extent to which the chief can try to corral folks today. So then we've got structural surroundings. And this is something that folks may not consider, but I think it's worth just talking about briefly. We know that our surroundings can influence what we do, how we think, and how we behave, and certainly how we interact with one another. You just take a look at these two offices. I ask you, which one would you rather be sitting in right now? I think the answer to that is obvious. And you can be cute with all kinds of other pictures as well. The bottom line, though, is that where you are situated, the environment in which you find yourself matters. And it mattered in 1972. What happened is when Chief Justice Berger ascended to the chief position, the very first summer he got there, he took a tour around the Supreme Court building, and he was looking at different things about where he could improve with the building itself. And he took a look at the way the bench had been shaped. So you can see here, there's a new and old version of the court. That old version was just 9 seats that were in a straight row, side by side by side. And this is how it was when Berger himself had argued a handful of cases before the Supreme Court back in his day in the Department of Justice. And he recalled that the justices, when they were asking him questions, they couldn't oftentimes hear their colleagues asking questions, nor could they see them because they were obstructed by people in between them. And Berger wondered whether that had an effect on the justices, whether it led to more interruptions and particularly some frustrations at oral argument. So what he did when he took over as Chief Justice is he had carpenters come in and just literally saw the bench and then give it that wing structure that you can see in the picture that says new. This way, his colleagues would be able to see one another when they ask questions, and they might be able to hear one another a little bit more effectively. And, obviously anyone who's ever experienced hearing loss or not been able to hear, how frustrating that can be. And that can spill over and lead to other problems on the court. So we know through communication studies, things like nonverbal communications are important. You've got to be able to see people sometimes to know what it is they're truly saying. And if you can't see what your colleagues are doing, that can be a problem. Eye contact, of course, is very important. You can know the strength of someone's position sometimes if they're looking you in the eye. And then, as I mentioned before, hearing loss can just have some very frustrating consequences across the board. So what we wanted to do, some of my colleagues and I, was to see whether or not there are any things that chiefs can do to kind of help with that communication display. And we used the Berger bench example as one particular example. So we looked at cases 10 years before and 10 years after his decision to do that to the bench. The variable we're looking at basically is how many times the justices interrupted one another in a block. All right. And this figure here, I think, indicates something somewhat interesting. This vertical line here represents where, and I apologize for the term values, represents when the court put that, made that change to the bench. And you can see that interruptions had kind of gone down, then they went back up again immediately beforehand. And then afterwards, interruptions really took a nosedive. So it appears that it had a slight effect. And of course, if you look at the justices who were farthest away from the center seat, those who were on the wings of the court, who before wouldn't be able to see their colleagues on the other side, but now actually could look down and see everybody, those folks on the wing actually had there was a much greater impact on them from changing the court structure. They were considerably less likely to interrupt than folks who were in the center. So it did seem to have a consequence. Now, the last thing I want to just point out here is to look at what would happen to the court today if it opted for televised oral arguments. This is something we've been looking at for a number of years. There have been a number of scholars and media outlets over the last 2-3 decades, frankly, who have advocated for the Supreme Court to open up and let cameras in the courtroom. The justices themselves have been very, very reticent to do this. Obviously, we don't have cameras in the courtroom yet. And even now with COVID, the justices, unlike nearly every other court in the country, have not gone to a Zoom format, but rather just the audio telephone format. There's a reason why, is they are very skeptical about cameras in the courtroom, and our evidence suggests that they should be skeptical of it. So we did an experiment where we took two courts, the Indiana Supreme Court and the Minnesota Supreme Court, and we had survey respondents listen to on one hand and watch and listen to on the other one of these two courts. And so in the Indiana context, people could watch or listen. And the way the Indiana courts operate is they'll have a camera fixed right in on the justice who's asking the question. And then when the attorney responds, it focuses closely in on the attorney, and you get that back and forth kind of thing. Whereas the Minnesota court, they just have one camera that pans over everybody from a distance. You can't really see faces very clearly. You just see court, and you see some judicial symbols, things like that in there as well. And we wanted to examine whether people who heard versus watched a court oral argument had different views on the court's perceived legitimacy. And one wrinkle we tossed in there is we had some respondents watch or listen to a very contentious exchange between attorney and justice, and others watched or listened to a very sort of normal, milquetoast, respectful exchange. And what we could see here in the Minnesota context, which was that very distant camera, is there really wasn't much of a difference between whether people heard it or whether they saw it. and whether it was contentious or non-contentious. So that that display from the background didn't seem to affect the legitimacy of the court all that much. However, when we get to the Indiana format, where the camera is zooming in on the justice and then zooming in on the attorney, we could see that in the non-contentious cases, the run-of-the-mill standard cases, people who see that are more favorable towards the court than people who hear or heard the case. However, that comes at a very significant cost. People who are watching a contentious exchange are significantly less favorable to the court than those who hear the contentious exchange. Now, from our perspective, we know that the media is more likely to focus on contentious than non-contentious. And so this figure right here suggests to us that a court cautious of its reputation, protective of its legitimacy, should be very, very reluctant to authorize any cameras in the courtroom for fear that this dynamic will take over, that the media will focus on the contentious aspects of the case, particularly in these hot button cases that are coming before the court this term, such as like the Catholic Social Service case coming out of Philadelphia and others. So we think that a court that's trying to protect its legitimacy, because it needs that legitimacy to survive, it has to operate as though it's in a fishbowl and everybody's looking at it all the time, because frankly, the public is. And this suggests that justices should operate with civility as much as they possibly can. The chief can help out with that by pointing out, as I did earlier, modeling good behavior using language that is not too nasty, but is respectful to others. I think the chief can also do things like exercise good leadership, try to focus in on some of that social leadership as well as the task leadership, and then use those structural surroundings effectively, whether it comes to things like thinking out of the box, changing the size of the shape, of the court, or thinking more broadly about how you use cameras, things like that. Those are all things that the chief can do to help build consensus among the court, if not in particular cases, certainly as a whole, I think, as an institution. So that's where I'm going to stop. Happy to take any questions we have.
And we've plenty of time for questions. And if you do have any to ask, do put them into the YouTube chat and we'll pass them on. And we've already had a few. So one of the audience asks whether it would be helpful for the court to have even more secrecy and anonymity. Is it unhelpful that we know how the court splits 5-4, or unhelpful that we know who authored particular opinions? Would it be more helpful if the court just issued its opinion?
Well, so that's an interesting question. And of course, that's the way it used to be on the court. When Chief Justice Marshall took over, for many years, we didn't have any dissents on the court. It was very, very rare that we would have dissents on the court. And, the justices at the time were very careful about that. They would actually tell their colleagues who were thinking about dissenting not to do it, because it's not good to be seen in public cutting down other judges. And that, of course, was during a time period in which the court's legitimacy was less strong than it is today. And so they had to really undertake a serious effort to maintain that legitimacy, protect it, and grow it. I'm not sure that I think greater secrecy would be necessary for the court. I think they have approximately the appropriate amount as it is right now. I do think that it would be useful for them to try to speak with one voice more often than not. I do think we have too many plurality opinions today, and nobody knows what in the world to do with a plurality opinion when it comes down. The court has told us through the Marx doctrine that we're supposed to pick the opinion that has the narrowest effect to be the one that has binding effect, but that's anybody's guess. So I do think they should do more internally to try to get to more consensus. But beyond that, I'm not sure what else we could impose on them.
And then we've had an interesting sort of methodology question. I think the audience was quite captivated by the sort of attempt to quantify sort of nastiness. And so we've had a question about how pleasant and nasty language gets defined, and whether it's whether you're picking up the broad tone of the documents, or whether you're picking up sort of direct attacks on other justices, or
Yep.
what you're picking up?
Yeah, so it's a good question, or a good series of questions. The way we did it in that study that I showed you earlier is there are dictionaries out there, software dictionaries, which will have come with predefined terms, saying like, these 1,000 words are very nasty words as we see them, and this 1,000 words are very pleasant words. And then what you do is you just kind of run the text of an opinion through that software, and it'll tell you what % of the opinion is within a particular category. But there are many other approaches that people can take to do this. This is actually a growing area of scholarship on the US Supreme Court, as well as other courts more broadly, is to take a look at the text and pull from the text what you can. So there are justices who use certain phrases more often than not, and their decision to use a particular phrase tells you a little bit about them. You can use the words sometimes that people use to try to infer their ideology, right? And we can see this in politics today, whether you talk about an undocumented person or an illegal immigrant, that kind of gives you an indication of where somebody is. So we can take a lot of these turns of phrases and pull out all kinds of different things about the justices. I just recently actually published a book with 3 of my co-authors looking at the texts of justices' pre-confirmation writings to get estimates of their personality scores. And you can use those measures to examine a whole host of things as well. So a lot of different ways to go about doing what we just did. That was just one particular approach there.
And then we've had an interesting question about sort of political pressure on the court. I'll just read out. What role do you believe the media plays in shaping Supreme Court decisions? And is this ultimately beneficial or detrimental?
The short answer is that we don't know the extent to which the media affect the court. I think the knee-jerk reaction on this is that if they do, it's probably not much. Justices, obviously, they've got lifetime tenure, and so they're secured from professional types of punitive responses that you might think of in other environments. Nevertheless, justices are human beings, and I think most of the time when human beings are attacked in the media, it's an unpleasant thing. It doesn't feel good. And we do know that some justices are more susceptible to this than others. Justice Kennedy didn't like to get attacked in the press a lot. Justice Ginsburg, from what I gather, was particularly bothered by it as well. And so whether that affects their opinions is up for debate. I think Justice Ginsburg used to say that the justices are not motivated by the weather of the day, but by the climate of the era. And so I think to the extent that the media affect justices at all, it would be that approach, that they do pay attention, they do see what's going on in the news. I don't think it has a strong correlation with their output in particular cases, but it certainly affects them. It certainly affects them. And one thing, just to kind of be a little bit informal on this, there's a study that was done, probably 20 years ago now, I'd say, where a couple of scholars went into the archives of the justices at the Library of Congress. And it's really cool. If you get the opportunity to do that ever, I'd say you should. It's a lot of fun. You can go find all the memos passed among the justices, things like that you never really see. But they found one series of memos that went around throughout the justices where they were actually betting on the outcome of the 1992 presidential election. So 5 or 6 of the justices basically did a betting pool where everybody would chip in $1 per each state, and then they would win if they successfully predicted whether it went to Clinton or to Bush. They would get their dollar back, and they did awful. They just did awful by and large. There was one justice who did well on this thing, and that was Justice O'Connor. Perhaps not surprisingly, she won something like $20-30, and then the second biggest winner was Harry Blackman, who won $1. Everybody else lost money. So I think it suggests something we know about the court is they're not really strongly political creatures. They're not paying as much attention as others are, and they're frankly not quite as good at it either.
I mean, just piggybacking off those sort of thoughts, because you focus very much in your talk on the role of the Chief Justice, but what about the sort of work that associate justices do? I'm thinking in particular of the relationship that, say, Justices Ginsburg and Scalia were supposed to have, during their time on the court. Have you looked at the way justices relate to each other, sort of outside of opinions?
Outside of opinions, no. It's just difficult to gather data on that. The justices are pretty tight-lipped about what they do in their private lives, which is obviously their prerogative. We have tried to look at some things like when they target other justices in their opinion writing. So if they're, one of the things that, in the short answer of that is that the data are sort of all over the place on this. It's kind of hard to pin it down. But one area that I think could be really interesting is when a justice writes a concurring opinion, sometimes they'll do something called riding shotgun, where there'll be a silent member of the majority, but they write a concurring opinion to attack a dissenter. And I think that would be an interesting interesting analysis for somebody to do, is to figure out who's riding shotgun and who are they targeting over time. I think that would be kind of neat to see.
Yeah, we've had an interesting challenge in one of the questions asking, if you were redesigning the physical layout of the court, what other changes would you make to improve it? Do you think there's more that they could do to think about the layout of the court?
I don't have a specific answer for the U.S. Supreme Court. I think having the winged bench is a good idea. I might try to angle that a little bit more. But it is interesting to look at other courts around the country and around the world. I know there are courts in Israel, for example, that are an entire circle where the attorneys are in the middle and they're surrounded by people. I'm not sure that's the best idea, because I wouldn't want to have my back to a judge at one particular time. But different courts operate with different ways, and it's something that we haven't really studied all that much. I can tell you here where I am, the Wisconsin Supreme Court, it looks very similar to the U.S. Supreme Court, but the acoustics are terrible. It's incredibly hard. There's so much marble in it. And the sound just bounces around, and it's hard to hear. It's very, very hard to hear for people, and that has to be frustrating during oral argument. So I would say, the audio side of things is something that should get a lot of attention from people, particularly when we have a lot of these attorneys are repeat players who are getting up there in age, as the justices are as well. It's becoming harder and harder for people to hear. I would look into that more.
Sorry about my cat. It's the terror of Zoom calls. There's a question about sorry about that. There's a question we've had about the sort of political appearances of Supreme Court justices, both becoming more political figures, making more public appearances, and also sometimes getting into trouble for what seem to be partisan comments. Have you studied at all the effect that those kinds of public personas have had on the workings of the court?
Well, I can tell you, so two things on this. First, my former graduate student, who's actually now at BYU, his name is Chris Cruson. He has done some work on the effect of these kinds of talks on the court's leadership. He didn't look at the political appearances. He just looked at what happens when a justice goes out and gives kind of your standard talk about the court and the rule of law. And his results indicate that it has a beneficial effect on the court, that when justices are out there kind of on the road, people get to see them, hear from them, that at least there's a short-term spike in people's favorability towards the court and their sort of views of the court's legitimacy. He didn't go much further into looking at the negative consequences of that. I know he did investigate it a little bit, and there were some effects there. But overall, I think they were swamped by the beneficial effects. Now, if there's a constant drumbeat of politicized stuff coming from the justices, that's going to be a problem. The other thing I should note, though, is I did a study not too long ago with my colleague Ryan Black, where we just looked at where justices traveled across the country. I mean, this is the kind of study you do once you get tenure, right? Because it's not earth-shattering or discipline-enhancing, but it is interesting. And we actually found that a few things were of note. One is that justices tend to travel more, of course, when they've got a book that they're trying to sell. That's not a shocker. Two, we found that they're more likely to travel to circuits where they are the judge of that circuit. So each justice oversees a particular circuit on the Circuit Court of Appeals, do things like grant or deny motions, that sort of thing. They're more likely to travel to those circuits. But what we also found, there was some evidence to suggest that they were more likely to travel to circuits that had been kind of a pain in their neck, right? So you imagine conservatives with maybe the Ninth Circuit or something like that. They're somewhat more likely to travel to those places. And that's even after controlling for things like temperature. Is it a nice place to be, a warm climate, that kind of thing. They do seem to visit those areas a little bit more. So it could be them trying to keep an eye on what's going on.
We've had several questions that I'm going to sort of group together, asking in different ways about the political influence on the court and the responsiveness of the court to those influences. And I think the answer you gave before about the climate versus the weather is an excellent way of thinking about it. But of course, there are other models in the US. There are elected courts that are obviously much more politically responsive. Do those courts have a greater legitimacy? Do courts that are more directly connected to the political process have a better sort of legitimacy for dealing with these culture war issues?
Yeah, so it's a good question. In terms of the U.S. Supreme Court, I'll take that first. The answer is roughly the same as you indicated, but we certainly have seen examples of justices who seem to have changed as a consequence of politics. The most recent of which I think is Chief Justice Roberts in the Affordable Care Act case. I don't know a single person who actually thinks that his sincere preference was to uphold that. I do think President Obama went out of his way to warn the court a number of times that he was going to go after it if the court didn't rule the way he wanted it to rule. And there is some evidence to suggest that could have had an effect on Chief Justice Roberts. But otherwise, there's not much effect there. So on to the state courts then. It's been a little while since I've looked at this scholarship, but the last I can recall of it, I think there was some pretty strong evidence to suggest that yes, the ability of the public to keep an eye on and check and vote out of office Supreme Court justices at the state level increased their perceived legitimacy of the institution. Just the fact that they knew they had the ability to vote them out if they wanted to had a very good effect. Now, sometimes that comes at a cost of people, seeing politicized courts, that kind of stuff. But even the negativity that comes out of that tends to get outweighed by the positive benefits people perceive with being able to elect in and elect out those justices. But of course, that's under a very controlled environment that we've had over the last couple hundred years. If things change and it gets really, really, really politicized, then we might see different responses there.
Do you see in the evidence you look at justices rallying around each other to sort of protect the court, and particular, we've had a question about, what's the behavior like after brutal confirmation processes? Do justices sort of show restraint, when one of their numbers had a particularly rough ride?
Well, what they tend to do is reach out to that person. So a couple of examples come immediately to mind. After Anthony Kennedy got on the court, of course, he was Reagan's, third selection. It was first Bork, and then it was Douglas Ginsburg for about a week, and then he went with Anthony Kennedy. As soon as he got on the court, Harry Blackmun reached out to him and he said, "Welcome to the good old number 3 club," because Blackmun himself had been a third selection for Nixon. So we do see that from time to time. Also, this is also including a Blackmun thing. So Clarence Thomas is good friends with Thomas Sowell, who is a conservative writer, journalist. And Sowell one time went after Blackmun pretty good in the press. And Blackmun was bothered by it, and Thomas reached out to him and he said, "I'm very sorry to see that, my friend has caused you such distress on this. I'll give him a call and ask him to tone it down a little bit. So you do see that from time to time on the court, with the justices kind of helping each other out, not necessarily circling the wagons publicly, but doing what they can behind the scenes to make sure that their friends and their colleagues are not put upon too much.
With that, I see that Scott has reappeared, which I think means we're out of time. But thank you very much indeed for a fascinating conversation and a really interesting way of looking at the work of the court. And thank you to the audience for some really interesting questions.
Yeah, thank you. Thanks to the audience as well. And thank you, Scott. It was great questions. Good questions.
Yeah, no, we, again, as coming to the conclusion of our day's programming, and want to express our appreciation to Dr. Owens and Dr. Cole for a fascinating program.